Yes, hello everybody. I'm Theodore Kostakis. I am a professor of international European law at the University of Grenoble and European Director of Research for the Cross-Border Data Forum, where we are doing a lot of research on all these cross-border data issues. We have today a great panel, the aim of which is to examine whether democracies could be able, through international cooperation, to respond to the challenge of setting satisfactory global standards for intelligence and law enforcement agencies' access to data, and to find solid and long-lasting solutions for international data transfers. As Bruno Gencarelli said yesterday, convergence is what brings us together. But the aim of this panel will also be to inquire what kind of solutions could be put in place while waiting for utopia to happen. Anxiety concerning the future of international data flows has reached an unprecedented peak during these last months, and companies around Europe, but also all kinds of data exporters, express massively their concerns. It is impressive to see, for instance, the number of submissions to the EDPB consultation on supplementary measures, which have just been posted online, and I was able to count 177 submissions, most of them from business organizations. So we need to address these concerns, and I hope that this panel will help provide some guidance. We have great experts in our panel. I will not present them, not to waste our time, but just very quickly, Joe Jones, who is head of international data transfers at the UK, who is in charge of the adequacy negotiation with the EU. Florence Renal, who is head of the European International Affairs Department at the CNIL, and she has been working on all these issues for a very long time and knows them very well. Ralph Sauer, deputy head of Unit International Data Flows at the European Commission, who has also taken a part in the negotiation, between other things, on Privacy Shield and today in the different adequacy negotiations. And Peter Zweier, who is professor at Georgia Tech, director of the Cross-Border Data Forum, and who has also worked several times with the US government under the Clinton administration or the Obama administration, and know all these issues very well. Could you please put the slide on? And I will explain very quickly how this will work. If you could open the slide, the 5 points, please. Just click 5 times to open the slide. So what we will do here is that we'll cover 5 thematic issues, and you see the time that will be allocated to each one. We have a great set of questions for these issues, and I will ask the auditors, if you have questions, just send them as it comes, so that we'll be able to introduce them. Without wasting time, let's start with the first set of issues, which is the issue of UK adequacy. And of course, the first question that I would like to ask, that I would like to address to Joe and to Ralph, is where do we stand with the negotiations on UK adequacy? Bruno Gencarelli said that the Commission is ready to launch the decision so as to meet the 4 + 2 months of deadline of the bridging period. Joe, where are we exactly with this?
Thanks very much, Theodore, and thanks very much for having me. I'm delighted to be on this panel in such distinguished company, talking about some very important issues. On this issue in particular, what I won't do is I won't speak on behalf of Ralph and my counterparts in the European Commission, but I'll set out where we have got to date, where we got to with the deal that was agreed on Christmas Eve last year, and our expectations in the UK government as to what should happen next. But just going back a little bit, it's nearly a year ago now that Prime Minister Boris Johnson set out the UK intention to get adequacy decisions from the EU. On the other side of the channel, the European Commission said that it would endeavour to adopt adequacy decisions for the UK by the end of 2020. We published a lot of very detailed technical information online. We shared that with the European Commission, and it set out the case as to why the UK should be adequate. and I'm very happy to share that material. But there was a particular annex, Annex H, that set out information relevant for this panel on national security. Fast forward, December the 24th, we agreed the Trade and Cooperation Agreement with the EU. And we had, up to that moment, made some very good progress with our counterparts in the Commission, but we did not have an adequacy decision adopted in time by the end of the year. So we agreed in the deal to that bridging mechanism that you mentioned, Theodore, a 4 + 2 month period where free flow of data can continue from the EU to the UK, whilst the EU goes through the process of adopting adequacy for the United Kingdom. Now, it's always been our position that there's no good reason why the UK should not be granted adequacy by the EU. We also don't see there to be a good reason why the process for adopting adequacy shouldn't be concluded promptly. Indeed, I know Bruno yesterday and various officials in the EU have made statements indicating that the process for adopting adequacy will begin soon. And so we, in the UK, we don't expect this bridging mechanism to be in place for more than 4 months, ideally, and certainly not more than 6 months, because it is, of course, in both the UK's interest and the EU's interest to have adequacy decisions adopted. On the specific issue of substance, now, the UK was, of course, a very recent former EU member state. Our data protection laws and our framework have not changed in any substantive way since we left the EU. So, of course, we absolutely expect that the Commission will find us adequate. We've been clear about that. We are compliant with the GDPR. We do have an investigatory powers framework in the Investigatory Powers Act. Of course, there is government access to data, and data protection and privacy are at the heart of not just our Data Protection Act of 2018, but they are also at the heart of our Investigatory Powers Act. Data obtained under that act is processed under that legislation, but also as part of other legislation under human rights. I'm sure we'll come on to this later, but that sets out, I hope, the UK expectations of the process. Recognise it's a unilateral process. It's done by the Commission, and then there are other influential EU stakeholders. And hopefully it sets out what we have done to date to move this process along.
Thank you very much. Ralph?
Yeah, first of all, good afternoon. I was disconnected at the beginning, so you would have to repeat the question for me because at that point I was not yet present. I've just heard the final words of my colleague.
I will repeat the question, which was where do we stand with the UK adequacy decision? We heard Bruno Gencarelli saying that it's imminent to launch the process. So this was the question. And if you can make some quick comments, if you have something else to add beyond what Bruno already said very recently.
Yes, well, on the latter point, that's probably difficult to go beyond what Bruno has already said. I guess we have certainly our limitations as to the substance in terms of process. And I think this was also just explained. We would have, of course, liked to finalize the assessment and certainly trigger already the adoption procedure during the transition period. For a couple of reasons, this was not possible. The bridging clause gives us now the time to go through an orderly process, and indeed we are very advanced. We are in the drafting stage, and that means we should be able to launch the formal adoption process soon, which, as you know, involves first of all seeking the opinion from the European Data Protection Board. So that will be the next step. They're independent authorities, so they also go by their own time schedule. I think, like us, they will recognize the importance of this particular process, and of course the need, let's say, to put the necessary resources there. So I would hope it's possible to receive that opinion fairly soon. Also, of course, given that on at least a number of the aspects we have very similar rules, because the UK is to a large extent still applying the same rules that were applying when they were still a member state. So, but of course, there is an area which they will have to look at for the first time, which is the entire field of government access. So they also need to have the time to go through this carefully. But as I said, the bridging clause is there to allow us to do this without putting any undue pressure on any of the stakeholders involved. If we can do this within the 4 months period, would be fantastic. If we have a buffer of another 2 months that we would then use if necessary. I think there's not more that I can say at this point in time.
Thank you very much. Precisely, I have a questions about the process, but first about substance. We have read the submission of some scholars like Korf and Brown on this issue, and more particularly, they have proceeded to an analysis of, you talked about the IP Act and the surveillance laws in the UK, and their conclusion was, I quote, this is my question for Joe, it is highly doubtful whether the processing of personal data by UK intelligence agencies, especially the bulk collection of communication data, is in line with the EU standards. So what would be your comments on this precise issue?
So I would say this, but I would respectfully disagree with that conclusion, if it is a conclusion. The UK, and this is not a new issue. I mean, this has been litigated for years now, previous versions of our current Investigatory Powers Act. Now, the Investigatory Powers Act, as I said earlier, puts data protection right at the center of it, and there are high standards in there. If anything, I would argue that our investigatory powers regime and the legislation that underpins it, the process that it requires, is world leading. The other important point, and I'm sure we'll come on to this later, is we have got to, and I say we, governments and organizations have got to put those capabilities and laws into context, right? And the right to privacy is a very important right, as are the government's responsibilities to keep citizens safe and to protect national security. And the Investigatory Powers Act does that. It balances that, the right to privacy to the responsibility of keeping people safe, and it has data protection right at its core with high standards. So I would respectfully disagree with those conclusions in that report.
Thank you very much. And precisely if we go back to the process that was mentioned by Ralph earlier, let's repeat to our auditors that the adequacy decision process involves a proposal by the European Commission, an opinion of the European Data Protection Board, an approval from representatives of EU countries, and then the adoption of the decision by the European Commission. So my question that I will first address eventually to Florence, but especially to Ralph and to Joe, is what happens if theoretically the European Data Protection Board gives a negative opinion? What could be the consequences? And let me just ask a very quick also additional question to Florence. Are you ready, taking into consideration the need to move quickly and the invitation by Ralph in his previous comment, are you ready to put in place all the necessary resources so that the timeline will be respected? Florence.
Thank you, Theodore. I hope you hear me well.
Very well.
Hi, everybody. Nice to be with you today. So to reply quickly to your question, Theodore, I mean, here we are in a situation with where the EDPB is giving an advice to the Commission. It's not a binding opinion. It's just an advice. I think in the past we have done a pretty good job highlighting the positive things, but also things that needs to be improved or eventually corrected. But after the Commission and the government that are part of the adoption can use it as they want. again, it's just an advice to them. With respect to the calendar, yeah, we know that we will have limited time to do it. We should soon receive the request for opinion from the Commission, and so I guess we'll be ready. It's more to the chair of the EDPB to answer to this kind of question, but yes, we know that the calendar will be tight. I guess that in terms of substance, we will look quite carefully about this aspect mentioned, the access by British public authorities to data protected by the GDPR. It's true that with the two recent case law before the CJEU and the European Court of Justice and the European Court of Human Rights, it will be for sure an issue that will be again look carefully. There is also this topic of onward transfer from the UK to other third countries that I guess will be also something that will be analyzed, especially in the light of the US-UK Cloud Act agreement. Here it's a kind of, as Ralph mentioned, it's a kind of special adequacy, because it's the first time that we will assess the legislation according to the GDPR, but also to the law enforcement directive. So we are getting prepared for that. I mean, we will adopt. We should adopt next week our referential for adequacy in the field of the law enforcement directive, in order to be ready and to do this review for the UK. There will be also, I guess, the regulatory alignment once the adequacy decision is adopted. That will be also looked at, and how we organize the review to make sure that there is still this adequacy and this level of protection maintained after the adequacy is given, and if it's given. And beyond adequacy, there is also another question that is interesting, and it's more a policy strategy question, is that the UK will have the possibility to adopt their own transfer tool according to their own legal regime. And so that will be, I guess, interesting to see the interaction between those tools and the EU tools and the rest of the world as well.
Thank you very much. Ralph, do you have any additional comments on this?
Again, coming second means that a lot of the important points have been made. As Florence has said, it is a non-binding opinion, but it is a very important opinion. The one doesn't exclude the other. It is the opinion from the independent data protection authorities that are the ones that have to interpret and apply and enforce the data protection rules. So we will obviously take this very seriously, depending, of course, also on what it says. I mean, there can be criticism, which doesn't mean that there is no way to go about it. Maybe sometimes it requires clarifications. It could also mean, as we have seen in previous cases, to perhaps work on additional safeguards if there is something which is a valid point and but perhaps can be fixed. I'm not saying this will happen, but I'm just saying there is also different outcomes and different content of such an opinion. Ultimately, it will be the Commission's responsibility, together with the member state representatives that have to vote indeed on the draft, to decide what to do. But because of that responsibility, we will obviously be quite wary that we don't take legal risks, and I say this, of course, in particular against the background of judgments that we have received on other adequacy findings. And the last one, obviously, is the Schrems II one, which highlights that not only do we have the scrutiny from the European Data Protection Board, but we also have judicial scrutiny, and I mean, it cannot be excluded, and we should in any event think as if eventually a court could look at this. I mean, I think that those are the parameters. But again, as I tried to indicate at the beginning, UK is very different from any other third countries in terms of where it comes from, the rules that it has in place, which have been shaped by decades of membership in the EU, and of course also the membership at the time when we modernized our data protection rules. This is very different from any other third country where we maybe work towards convergence. Here we start from converging rules or identical rules. And of course, the UK is also a party to the European Convention of Human Rights. It's also something which one should perhaps not leave unmentioned. That's also something which distinguishes the UK from many, if not most, of the third countries that we have looked at previously. And that's, of course, also relevant for the area of national security, for government access. So
thank you. Thank you very much. Joe, you have the last word. If you could keep it short on this first set of questions. Thank you.
I'll keep it brief, but I think, look, I would like to stress the fact that these are not, we're not talking about esoteric legal mechanisms here. You know, adequacy decisions can underpin, in this case, billions of pounds, euros of trade. They can support and underpin very close cooperation on national security and law enforcement matters. So it's incredibly important. We get it. I know Ralph and his counterparts, his colleagues get it. And I think we need to put it into that context.
Thank you very much. So let's pass now to the second set of questions from the UK adequacy to the US adequacy. And I will start with exactly the same kind of question, which is, where do we stand in EU-US negotiations concerning adequacy following the invalidation of the Privacy Shield? I give the floor to Ralph first and then to Peter.
Yeah, so you might have seen that following the Schrems II Judgment, not very long afterwards, there was already a joint press statement from my commissioner, Commissioner Reinders, and then Commerce Secretary Ross, which confirmed the interest and readiness and willingness of both sides to engage in a dialogue to work on a successful arrangement in full compliance with the judgment of the court. I think that's the important part. Obviously, you also are aware that of course we had a period of transition since the elections, which meant that I mean that's just a general policy of the European Commission, but of I guess any other third country as well, not to engage in negotiations during a transition phase. We have nevertheless had constructive contacts with our US counterparts to I would call that exploratory talks, which had the purpose to, first of all, get a common understanding as to how we read the judgment, what we understand from the judgment, and to already maybe float certain ideas of what could be possible solutions. I would say we are not yet further than that. There's still certainly a lot of work ahead to I mean, the devil will lie in the detail also here. And of course, it's not an easy judgment to deal with. It's not easy also because it concerns a very sensitive area for any country. Any European country would also be very concerned about discussing these things and with a third country and working towards solutions. So we need to have that understanding also for our US partners. But it's clear that there is a lot of willingness. You will also have seen the statements that were made by the new Commerce Secretary, including even in her confirmation hearings, And of course, more generally, there is an agenda which was expressed very clearly by the European Commission of now strengthening again transatlantic cooperation, and that is certainly working on a solution here is a very important part of it. But I'm just saying we are certainly not yet there. We are certainly still in an exploratory phase, and of course it also remains to be seen what type of measures can be envisaged, and whether these are non-legislative measures or whether for something legislative changes might be necessary, which of course will have a very significant impact on the time schedule. So I mean, those are a number of questions. Peter Swire is on the call, so he has already extensively written about this, and you can see that there are many creative ideas, I would say, about how to address certain issues. But ultimately, it's of course also for the US side to know what they can do legally in their constitutional and legal framework, and politically are ready to do, and for us to assess whether that goes sufficiently far to comply with the judgment.
Thank you very much. And while keeping this first question for Peter, I will add a second one also for Peter. This panel takes just a few days after the inauguration of the Biden administration. We have heard a lot of positive comments from both sides of the Atlantic. There is a lot of good willingness. We heard constructive comments. While giving you your view on the general issue, what do you think, what kind of early initial steps could be taken either by the new administration or eventually from the European side that would be constructive in order to find solutions to these issues? Peter.
Thank you, Theodore, and it's great to be back at CPDP this year. I've enjoyed coming for many years to Brussels, and I'm sorry we can't be there together in person today. I'm going to first talk about some of the difficulties and frustrations, and then I'll talk about some of the early steps that could be taken. I've been listening to other panels at CPDP and watching these issues, and when I teach privacy, I talk about privacy and data protection from two sides. One is the rights of the individual, the data subject. Another is you have to actually build systems that process data, the perspective of the controller and the processor. And from the perspective of fundamental rights protection of the individual, there's a great frustration that I've seen from people working on these rights that there have been repeated court judgments, but it seems like there's little progress towards actually changing things. And so it seems, for instance, maybe that the Court of Justice's opinions are not being followed through in practice at nearly the way you'd expect from the rule of law. And so that's an intense frustration from people focused on fundamental rights protection. From the point of view of people who actually build systems, there's also intense frustration. So most companies that trade outside of Europe, or at least with the United States, they never receive a national security investigation. And yet they're being told under European law that the entire regime is so inadequate that their entire international business operations seem to be illegal under European law. And imagine if you were the controller or the processor doing that, and there's nothing you can do, and it has to do with requests that have nothing to do with your business. So there's frustrations intensely felt on both sides. And if we don't protect fundamental rights, we're violating the fundamental documents of European and international rights law. If we're not looking at how business actually operates, we're hurting the economy and hurting the national security that's necessary in a democratic society. This is really difficult and very frustrating, probably for everyone involved with it. So how do we get through that? Well, one of the ways we get through it is by having people listen to the different perspectives and have knowledge about these things. And on that, I think the new administration has shown already that we have reasons for optimism. So within the first day of the Biden administration, they appointed Christopher Hoff to be the lead person for these issues with Europe Privacy Shield related issues. And he's an experienced international transfers expert. So we have somebody in place literally on the first or second day of the administration. The Secretary of Commerce, in her confirmation before she's even in place, is saying this is a priority. It's also worth noting that President Biden himself has worked with the EU in the past on data issues. It's worth noting that Vice President Kamala Harris was Attorney General in California, where she was known nationally as a leader on enforcing privacy rights. So within the administration, and this happens all through the people who worked on the Privacy Shield and the rest, there's a level of knowledge and awareness of the issue that's quite remarkable. But that doesn't make the issue easy, but at least gives a start that there's people there who can engage with it and in goodwill try to find ways to do that. I think one of the things, and I've talked with Theodore Kostakis about this, is on the way towards any eventual agreement, there can be, in diplomatic terms, confidence-building measures or diplomatic assurances. There can be steps before a final agreement that show the goodwill of the parties. And I think for the United States, I think it's worth considering concrete specific points. What can we be doing on redress? What can we be doing on proportionality? What can we be doing to address other specific concerns? And of course, there's an element of negotiation where you don't put everything on the table at the start, but there may be public measures going beyond the white paper that could be taken that could at least help with the early discussions, I hope.
Thank you very much for being for being so concise. Precisely one of the major issues is how far could the US go toward the direction of addressing the main deficiencies in US intelligence laws highlighted by the Court of Justice in Schrems II, namely judicial redress and proportionality. When I read the submission, I read this morning the submission of the United States to the EDPB consultation, and it starts with ensuring that companies are not required to take actions that adversely affect national government's responsibility to protect public safety and pursue justice. So we see this concern always and always coming back about not weakening tools that could be interesting according to the United States for national security purposes. So Peter, what is your take on this? How far do you think that we could expect the United States could go?
Well, my hope on redress is that we now have a path forward that would comply with both US and European law. And as some of you know, with Ken Propp, who was a longtime State Department lawyer for the US government, we proposed a path forward on redress. And a difficulty under US law for redress is what's called standing doctrine, which is somebody from Europe cannot walk over to the United States and go into federal court and have the right kind of injury or standing that enables the federal judge to make a decision. But the model we propose would be the European individual or through a DPA could make a request, and that would trigger a mandatory duty on an agency, a federal intelligence agency, to do an investigation. And then that mandatory duty could be reviewed by an independent body, such as the Privacy and Civil Liberties Oversight Board. And we've shown ways that it could then be reviewed by federal judges with lifetime tenure and full independence. The model for this in the United States, if you want to get documents from the government, you can do what's called a FOIA request, a Freedom of Information Act request. And you don't have to be injured before you make a FOIA request. Instead, you say, I would like to get this action from the government, and then the agency has to do the action. And if it doesn't do it properly, the judges can say you haven't done it properly and order a required change in activity. And so it's that kind of triggering the mandatory review that I think is possible in redress. We proposed a statutory version of that back in August. In my testimony before the US Senate in December, I put forward ways that can be done even before a statute is enacted and still get to judicial review. And so I think for redress, and I might stop there and let others comment, I think on redress, we have a path forward that complies with US law and that gives the individual redress for concerns about violations of rights. That's been such a highly stressed point in the European court system.
Thank you very much, Peter. And may I ask the same question to Ralph, if he has something to add? Do you feel that the US could go far enough to address the issues raised in Schrems II? And may I ask a question also, because as a mirror, there are always a lot of questioning concerning European intelligence laws, a lot of things to say, and we know that they are constantly challenged and struck down at the European Court of Human Rights, for instance. And do you think that this whole process might also lead, in order also to embark one of the questions, and I will try to do it as it comes, we have very interesting questions for this panel. Do you think that this could also eventually, this whole process, help European countries improve their intelligence laws?
Yeah, I mean, thank you very much. I mean, all very, very good questions. Let me just start one thing, because you mentioned the US submission in the consultation on the Schrems II guidance or recommendations from the EDPB, and of course I have seen them also, and indeed they deal with things like encryption or concerns around that, or concerns about sort of excessive challenging, let's say, of requests by companies and other things, and of course, I mean, some of these are probably legitimate concerns, and for example, encryption is one of these topics where indeed there is a very difficult balance to be struck between protecting privacy on the one hand, and at the same time still allowing important public interest functions to be carried out, such as national security. The same applies for criminal law enforcement. So, but that's exactly why it is much better and to focus on a comprehensive solution, a solution where we address together with our US partners the court's concerns, which would then ensures that there isn't proportionate government access, disproportionate government access, that there is redress for individuals, and that on that basis we can have an adequacy finding to avoid other types of measures being employed. So that's just maybe as a starter. That's why we have also a strong interest to work together, despite the sort of disappointment from the past and the striking down of two adequacy decisions. We are ready to do it again to have this conversation. In terms of what the US can do or not, I think it remains to be seen. It's clear that it is not easy. That has to do with also indeed the constitutional framework to some extent when it comes to standing, when it comes to creating independent bodies, and it has to do with the fact that, of course, it goes into very sensitive areas of how to apply FISA, how to create further limitations around this. All of this is not easy, and as I said, it's not even clear whether it can be really done at a non-legislative level. And that's the discussion which we are having, and I can't say more than that. On your last point, on the member state intelligence laws. Well, first of all, it's of course correct that also member states have to comply with the standards set by the Court of Justice, because it's I always hear that this is an area which is completely unregulated by EU law, which is not the case. The boundaries and limitations are, of course, regulated or determined also by the Charter, and the court's judgments make that very clear. But there's also, of course, the Convention on Human Rights, and there's national courts which look at member state intelligence laws under national constitutional law, and indeed there have been annulments there as well, which shows that member states also indeed have to improve, some of them at least. But we have a system of dealing with this. So what I cannot accept is to say we have double standards. Yes, practice might not always be aligned with legal requirements, but we have a system that helps us to address this. And I would certainly think that Schrems II and other judgments are also should be a trigger to reflect on our own rules and practices in the EU and member states on national security. And then beyond that, I think, which is very good, I think we see the beginnings of a discussion at global level. There is an initiative by the OECD, there is an initiative by the Council of Europe, and I think these discussions, and we have, of course, the work of the UN Special Rapporteur for Privacy in the past, And I think that is also an important discussion to be had, to develop global standards for government access.
Yeah, thank you, Ralph. We will discuss all this in the fifth point. Let's move immediately, as we're running 4 minutes late, to the third set of questions, which is extremely important and concerns what happens without an adequacy decision, either pending an adequacy decision for the US, for instance, or for countries like China, Russia, India, etc., for which there is no adequacy decision, at least in the foreseeable future. So I have a big set of questions for Florence first, which concerns the EDP guidance and what could be the future of SCCs following this EDPB guidance and the new draft SCCs by the European Commission. Giancarelli said that they should be finalized by the month of March. So my questions, Florence, and you can answer to this whole set of questions together. Could the EDPB revise its supplementary measure recommendations? You have received comments by 177 stakeholders with ideas, with suggestions. Could we expect something, a substantial revision? The risk-based approach, could a risk-based approach constitute a proportionate and satisfactory solution? We show that in your recent opinion on the Commission SCC's draft, you have expressed a lot of doubts about this. And if not, is it possible to find other solutions, for instance, the use of derogations to provide for flexibility and continuation of international data transfers in order also to buy time for negotiators? Yesterday, it seems that the judge, the rapporteur in the Schrems II case, Judge von Danwitz, was quoted yesterday as saying that a more flexible approach on derogation could be possible as a solution. So what do you think about all these issues, Florence?
Thank you, Theodore. Yeah, that's a bunch of questions. So I will try to reply briefly, but at the same time precisely to that in a short amount of time. So on contractual, on the new set of contractual clause from the Commission, we have adopted a mid-January our joint opinion with the EDPS on this new set. We have made a couple, some remarks. I will not enter into the details here because we don't have necessarily the time for that. But for example, we highlight the problem of readability maybe of the new set. Sometimes it's a little bit complicated to follow the different modules and what it corresponds in terms of transfer scenarios. So maybe here it can be clarified, but it's more a format, a presentation aspect. On the substance, we have also listed a series of remarks with respect to the fact that things should be improved or reinforced on onward transfer, on the rights, on transparency, and so on. A number of elements we think that it needs to be improved. What is also maybe important to stress is that those clauses can be used once the evaluation of the third country regime has been done, and depending on the result of the evaluation, this clause might need to be complemented with supplementary measures, according also to what we provide in our recommendation. So it's important to understand that they don't necessarily work at themselves. I mean, they have also sometimes to be complemented. What also is important to stress is that this tool is a very, very important tool for companies. I mean, they have been used for many years. The new ones will be also very much used by French actors or by EU actors. So it's important that we are on the same line with the Commission on its content and that we feel comfortable, because we have also the duty to enforce it, and we know that it will be a lot used by our actors. So it's true that it's important that we have the same views on the content, and also maybe one aspect is that we have also to pay attention to create some distortion between transfer instruments. So we need to be careful to have the same level of protection, whatever the instrument that is being used by the company, not to have different content and layer of protection depending on the instrument. So that's for the contractual clause. And now I think the second question was on the the revision of the supplemental rules and our recommendation on those. Well, it's a bit too early to say whether or not we will revise. As you have said, we have received many contributions, so now we have to digest them. It will for sure take a little bit some time, but at the same time, we are totally aware of the urgency and the importance of finalizing those recommendations in order to provide some legal certainty to the companies and to the organization that transfer data. So we are totally conscious about the fact that we need to move fast. But again, it might take a little bit some time to do it, so I mean it's a bit too early to say whether or not we will revise them. On the risk-based approach, so that's a very interesting topic. I mean, a great deal of ink is being spilled on this risk-based approach. Just to maybe to share a little bit some interrogation or doubts that we have on the risk-based approach. The first thing that we are not totally sure that the ruling really opened the door to the risk-based approach. The word is never used in the ruling, and on the contrary, there are many references to the fact that the protection applies whatever the sensitivity of the data is. And the judge, in fact, never really consider whether in reality data are accessed, but more if the legislation allows, in theory, this access. So I would say that's maybe the first point. The second point is that in practice, there is this idea based on the likelihood of this access, that certain data can be more interesting than others or more useful than others. But it's very hard, in fact, to know or to assess what type of data could be interesting for the intelligence community. The criteria for targeting that data are not known. On the contrary, the selectors are defined depending on the given investigation and on the given threat to face, and the definition of threat are quite broad. So it's very hard to know in advance what will be the scope of the investigation. And so what will be the data that will be useful in order to find to find a solution for this investigation. And the requests also are in most cases confidential. I mean, they are protected by secrecy, and it's very hard for EU companies to have the information that there have been some requests for access in the US, for example, to US service providers. I mean, it's confidential. They don't allowed to give this information. And the last point is on the concept of the risk-based approach itself as it is viewed in the GDPR. The risk-based approach is a principle that is used in the GDPR in order to modulate the use of compliance tools. So it's in order to decide whether or not you have to put in place certain compliance tools. For example, if you have to put in place a DPO or a DPIA, or you have to run a DPIA. But it doesn't mean that if there is no risk, there is no protection. It's not the approach, the philosophy of the GDPR. Anyway, you will have some protection, and whatever the data you collect and you process, people will have rights on this with respect to this processing of their data. So the risk is really used in order to define whether or not you use certain tools. So that's why we have a little bit some difficulty to understand how it will applies to the situation. So that's why to share some interrogation and some doubt with you, we are not totally comfortable with that, and we think that it's even more risky for companies at the end to use a subjective approach, risk-based approach, I would say, so to based the protection on whether or not it could be interesting for the intelligence community, than to base that on what the text is saying. It could be, in fact, in a say more not easy, but more certain to do it like that. On the derogation, yeah, here as well, it's a tricky issue. It's true that the reference of derogation is foreseen in the ruling. Our understanding is that it looks like it's an explanation also on the fact that the privacy shield can be invalidated retroactively, so with a kind of huge consequence. So it never existed in reality. I mean, that the consequence that it never really existed legally and in reality. And so, but the judge is, in a certain way, explaining that it's not a problem. There is no legal vacuum because for certain situations you have derogation. So it's a kind of a justification for this retroactive invalidation. And we are, I mean, it's really hard to understand the rationale where it would be said that there is a high level of expectation and high condition for transfer of data with respect to adequacy and transfer tool, but at the same time you can open the door and use derogation for this type of transfer. I mean, there is something here that is very very hard to understand. Also, derogation are derogation by sense, I mean, by nature, so they should be used in an exceptional manner. I mean, they are not supposed to replace the rule. If it would replace the rule, it would in a certain way deconstruct Chapter 5 and part of the GDPR. So that's why we're not totally convinced that you can use, I mean, derogation now for any kind of transfer. It needs to be, of course, specific or necessary for certain type of transfer. It needs to meet some condition. I think that's all. I think I did it.
Okay. you did perfectly well. Thank you, Florence. But as I'm going to give now the floor to Ralph to answer eventually if he has any reactions to what or things to add to what you said, may I ask an additional question on this, which is that the anxiety created by Schrems II and the EDPB guidance pushed companies to invest millions of dollars in requesting legal advice from law firms for their international data transfers. And when we see the dozens of submissions, for instance, by companies and business organizations to the EDPB consultation, we think that just putting these comments, let's not forget, let's forget all the rest, together was such a great business for law firms. So if we introduce also the part of assessing foreign countries' laws, this has become a very lucrative business, which is good for law firms, of course, but probably too expensive for business. So my question is, how to avoid companies being ruined, paying millions to lawyers in order to be able to deal with the situation? Could the EDPB, for instance, or the Commission proceed to a kind of centralized assessment of foreign laws to help companies deal with this? This is something that comes all the time in the submissions to the EDPB consultation. They request centralization. Don't let us alone with this. What do you think, Ralph, and eventually Florence afterwards?
Yeah, so then I start with this last point. I also would have a couple of additions, not so much comments on the other questions. I think one thing is that's important to recognize, and I think it's clear from the EDPB recommendation as they currently stand, that the assessment that has to be carried out for the use of SCCs or other appropriate safeguards is not the same as you would do in an adequacy assessment. It is a targeted assessment with respect to the specific transfer in terms of the type of data that you send, the type of recipient, and so forth, because you have to check only those laws and practices that concern that particular type of data, that particular type of recipient. So if I send content data to a certain provider, I should not have to worry about rules that, I don't know, allow the collection of metadata or if I send something to a financial institution and the law allowing government access does not apply to financial institutions, but only to communication service providers, I shouldn't have to worry about this. So there's a difference between the type of assessment that we have to do in an adequacy assessment, which is comprehensive, and the type of assessment that companies have to do. And I think, I mean, that's part of the answer, that we cannot indeed do this assessment for companies. It depends on from case to case. And then, of course, there's also, as you will know, if you would have to do sort of basically comprehensive assessments for every aspect of any third country law, it is simply not feasible. You know that this is complex work, which takes us time and requires resources. With this, I'm not saying at all that companies should be left alone with this. I think what is important is very clear guidance from the EDPB, identification of measures that can help to address many different situations. I mean, I think that is the way forward. On the question of what has been termed risk assessment, and indeed it is not the risk assessment that the GDPR has in mind. I think one should just leave that aside. But the question is, does the ruling leave room for a form of risk assessment, or an assessment of the likelihood of being subject to government access? I fully understand the difficulties that the data protection authorities have. Again, it's not an easy judgment to read, and I can also understand the concern of how do you develop a standard that can be applied with a measure of legal certainty. I can understand and see all of this. At the same time, I don't think, we believe that the judgment leaves some flexibility. I think the judgment focuses on the question of whether third country laws or practice prevents compliance by the data importer, and I think that gives some margin of seeing. I mean, if you're very unlikely to be subject to certain measures, does that then really prevent you from ensuring compliance? I think there is room that gives some flexibility to take into account a number of factors, including past experience. Maybe not as the only factor, but as one of the factors to be taken into account. And you have seen that we try to reflect this in the draft SCCs. That is currently not the opinion of the EDPB, but in their opinion, they have nevertheless said that, well, you have to look at the final EDPB recommendation. What I don't think is that this is subjective. Taking into account things like past experience is objective. Of course, it's done on a case-by-case basis, but it's not something which I believe or I think it is whether or not I have been subject, for example, to government access. Very briefly on the derogations, I think that's also important. I share the view of Florence that this cannot be the answer. This cannot be the answer to the question of how to ensure that data is protected when it goes to a third country. If you use derogations, not only would you not address the issue of government access, but there's no safeguards. So even on the, let's say, commercial side, you don't have safeguards. That cannot be the possible outcome of the judgment that you now on a grand scale rely on derogations. And as Florence said, they are what the word says. They are derogations. They're not supposed to be used in I mean, as a standard transfer tool. And so, with all respect to Judge von Danwitz, if he has said what I've also read, what he might have said is, I think one can say safely that he has spoken in his personal capacity. Florence, using a bit the French expression, spoke about what the judge said in Schrems II, but the judge in this case is a bench and actually a grand chamber, and not an individual judge. And so when the question comes to the Court of Justice, it will decide it. But at the moment, I think we have the guidance from the EDPB.
Thank you. Thank you very much. Florence, I guess that you want to speak about this. Just keep eventually your comments because we're running out of time, and there are also fantastic questions from the audience. And I would ask Joe to prepare some answers, not immediately at the end. If the UK doesn't get adequacy, or its adequacy funding is struck down, what hope is there for other countries to get adequacy? This is the first question. Or another one, for instance, also to Joe, is the UK considering granting adequacy or similar to the US or any countries after the end of the bridging period with the EU? So please, Florence, keep your comments, and Joe, your answers to this, and make them short. But let's dedicate 5 minutes to the fourth set of questions, please, which are also very important because they concern government access to data, but law enforcement access to data. And let's not forget this, because all this is part of the same equation. And I would like to ask Ralph very quickly, where do we stand with this EU-US negotiations for an agreement on e-evidence and Cloud Act, government access to data for law enforcement purposes? There is already a process of negotiation going on. There have been several rounds. And my big question for you, as you will not be able to give us a lot of details, but do you think that Schrems II affects these negotiations? And second, have you ever thought with the United States of enlarging these negotiations in order to include all these Schrems II issues? Or this is something that should not be part of an international treaty? Ralph.
You want me to go first? Okay. Indeed, I'm quite limited in what I can say there. I mean, those are confidential negotiations. Any international negotiation is confidential and rests on a measure of trust. So I think what one can say is that we are still relatively at the beginning of this. That they were to some extent also affected by COVID, and in fact also by the fact that the negotiators on both sides are actually quite involved in another type of agreement that also concerns e-evidence, which is the negotiations on the second additional protocol to the Cybercrime Convention. So a multilateral agreement which also covers access to electronic evidence, and where, by the way, data protection plays a very important role. It is clear that Schrems II applies to any instrument that seeks to ensure appropriate safeguards. So that would be Article 46, certainly, of the GDPR as a whole. And to the extent that an agreement would allow direct requests to service providers, the service provider, when transferring, has to ensure, has to have a transfer tool, and that can only be Article 46. So in that sense, I would think this applies, and I would think, although the court hasn't decided it, that nothing different would apply to appropriate safeguards under the law enforcement directive, so for judicial cooperation. But you also know that we have an agreement with the United States on data protection, a dedicated agreement, which is the umbrella agreement, on which the eventual e-evidence agreement will, of course, rely. Whether there is a need to adapt that agreement, for example, because it is very much focused on judicial authority to judicial authority cooperation rather than a direct request to companies, for example, is another matter. So there might be, and you can see this in the public mandate for the negotiations, there's a need for certain adaptations. But in principle, we have already agreed on the way we exchange data with the United States in the umbrella agreement.
Okay, thank you very much. And I will give the floor also to other persons, but let me turn to Joe and to ask, where do we stand with the entry into force and the application of the US-UK Cloud Act agreement? And could this agreement influence in any way the decision on UK adequacy? First to Joe, and then also eventually to Florence, because the EDPB has made some comments on this US-UK Cloud Act agreement. And if, Joe, you could take advantage during your answer to respond also to the two questions asked by the audience. Thank you.
Okay, I'll do my best, and they're good questions. So on the UK-US Cloud Act agreement, which has been signed by both parties, and we've completed the necessary periods of scrutiny in the UK Parliament and also in the US Congress. That has not entered into force. Both the UK and the US are fully committed to that agreement. We're still in discussions with our counterparts in the US. And just being very brief, of course, the Commission has taken an interest in onward data sharing, but there's no contradiction between the UK-US agreement and the UK receiving a positive adequacy decision.
Go ahead.
So that's on the UK-US agreement. Would you like me to turn to the other questions now? Or do you
Yes, if it is possible.
Okay, great. So the question was plans for other countries. And at the risk of repeating what Ralph said around confidentiality, there's only so much I can say. What I will say, though, is that the lay of the land is very different internationally than it was 5-10 years ago. There are a lot of countries implementing data protection legislation. I think it's right that governments should be speaking and engaging and partnering with their international counterparts on these issues. And I think there are lots of opportunities there. What hope is there for the Commission if the UK, or for the EU, if the UK does not get EU adequacy? What hope is there for other countries that might like to get adequacy? So I'm not going to speak on behalf of Ralph there, but I will say the UK is a perfect candidate for EU adequacy. Never before has there been a country that has been so aligned with the EU in terms of the GDPR, in terms of the European Court of Human Rights, the jurisprudence, the approach and the philosophy to privacy issues. And as Ralph said, we start from that position, and we did from the 1st of January this year. I'll leave it there just in the interest of time. Sorry, I was a whistle-stop tour.
Thank you very much. And Florence, do you have any comments on this? But we only have 9 minutes left, so if it is possible to keep them brief, because it's very important to speak about the global level also.
Yeah. Yes, thank you, Theodore. Well, just to say that, yes, we issue some position on, not some position, but some general remarks on the UK-US agreement. I remember there was something about prior judicial authorization that we thought was not that clear in the agreement. And I guess the main message is to the Commission. I mean, to make sure that they are covering this aspect in the evaluation, the assessment of the adequacy with respect to this onward transfer from UK to the US.
Okay, thank you very much.
Yes? I just wanted to because I forgot and I don't want to put off the European Parliament. I should have also said, of course, that one other reason why the negotiations with the US have been paused to some extent is, of course, that we had to wait for the European Parliament's opinion on our own legislation. I mean, not opinion. I mean, there's a trialogue, there's a process whereby the European Parliament defines its position. And of course, that agreement is directly linked also to what we do in our internal legislation. So I should have said that. That is also an important reason why we couldn't advance.
Yeah. Absolutely, and the Parliament has just adopted recently a position on e-evidence. So let's move to the global level in the 7 remaining minutes, because it's very important. And the question, I don't know who would like to start. What could be the building blocks and principles for a satisfactory global regime for government access to data at the global level? Is this a fantastic opportunity to find solutions at the global level, not just in transatlantic relations? And let me add immediately my second question, as we're running out of time, and you can include it in your responses. What to think about processes such as the data free flow with trust, which was launched by Japan, and the subsequent developments in the OECD, or even the Council of Europe in relation, for instance, with Convention 108 and other developments. So I don't know who would like to start.
Can I make a quick intervention?
Peter, go ahead.
So one thing, and this is happening, I think, with the data free flow with trust effort, there's a set of countries that are democracies that have institutions and a history of rule of law. And you can imagine certain sorts of agreements and principles where there's judges in place, where the judges' decisions are independent and implemented before the government acts. And so I think that there's a possibility of serious discussions among countries in that category that would not be completely global. Not every country has that same history of rule of law or institutions in place. And so you might really work towards principles under democracy and rule of law and human rights, and not expect to get every country in the world in on the first round.
Florence?
Yeah, do you hear me?
Yes.
Yes, I have two main points about the question. I think really the sanitary crisis has crystallized intense discussion in Europe about digital sovereignty, and we have seen people, companies, civil society worried or criticizing the fact that EU is too much dependent from foreign actors in the hand of other, foreign actors or foreign actors, and they want to see their data managed by EU actors. They do not want their data necessarily transfer abroad. We have a good example in France with the HDH, the Health Data Hub. I don't know if you have heard about that. With a committee of French doctors that were really opposed to the fact that a huge amount of health data of French citizens are stored within a US service provider. And it was a huge discussion. It was not here about transfer. It was really about access directly from the French territory. But I think, yeah, we should then acknowledge this change of spirit and take that really into consideration, because it's a feeling that is growing. But the good thing is that we hope, we think that there is we should have faith in the future. Ralph mentioned the initiatives at the OECD, at the Council of Europe, in the past at the UN. We have also initiated something at the GPA, at the Global Privacy Assembly, on that question. And it's very important. I mean, we are supporting a lot those initiatives. We are very active, participating in all the discussion, ready to help. And what is a relief is that it looks like there are, as Peter said, some countries that are sharing key principle or key values. And we hope sincerely that it will gain support, it will flourish. And I hope that, at the end, we will manage to agree on some key principle with respect to government access, because otherwise the risk is that we will have data localization initiative. And so in order to avoid data localization and to keep the spirit of the GDPR that's in the open, with condition, but open, we have to build trust. I mean, we really have to develop this trust. And I think this panel was about that. Thank you.
Thank you very much. And Joe, I see you waving positively your head. And now the UK as a sovereign nation will be an entire stakeholder in all these processes. So what do you think about this?
Well, it's not just about the UK, and I'm glad you introduced this issue in the global context, because there is this undeniable and sometimes quite difficult relationship between how we ensure that cross-border data flows are protected in the sort of commercial private sector sense, and the very real need for democratic governments to access data to fight serious crime, terrorism, and to keep its citizens safe. And it is going to require a concerted effort amongst like-minded countries and partners to resolve this. And to that end, we definitely welcome initiatives like those of the OECD to develop instruments that will set out high-level principles or policy guidance for trusted government access by public authorities of data held in the private sector.
Ralph, you have the final word. We have 1 minute and a half left.
I should be able to fill that one. No, I mean, I already alluded to it earlier and prematurely probably in this discussion. I share the view that of the importance of this, and I think it needs to be tried. It should be tried. Will it be successful is maybe an open question. Will we be able to agree on principles without making them so general and so high level that they lose meaning? So I think that's the question. I'm deeply involved in the negotiations of the second additional protocol to the Cybercrime Convention, so that it's not national security but criminal law enforcement. And some of the discussions that I see raise at least a bit the question: will we be able to bridge the divide if even on certain essential things like judicial redress, we're having very complicated discussions whether or not certain countries can ensure, for example, effective judicial redress even in the area of criminal law enforcement. So I hope that we can and that this work will bear fruit.
Yeah.
So I think it needs to be tried, and we are very engaged both at the OECD and if the work starts at the Council of Europe, we will of course also be engaged there.
Thank you very much to all for this fantastic panel. We could continue the discussion for hours. Many thanks for your concise responses, and to the public for the fantastic questions. We have been able to take aboard some of them, but unfortunately we're running out of time. Many thanks to everybody.
Bye-bye.
Thank you.
Bye.
Very much.
Bye.